Już chyba powinniśmy rozpocząć kolejny panel po przerwie. Czeka nas wiele interesujących wystąpień i wobec tego poprosiłbym może o zabranie głosu. I'm asking for a paper. Simon Cara, University of Castellanza in Italy, Industry 4.0 and Employment System, and Irreviable Culture Gap, please.
Okay, thank you. How long we take as contribution? 15 minutes. We can. Okay. Well, I think that in this moment we are a little bit in the end of the story, and as a discussion on a labor perspective. At least. I have the Italian perspective, at least as far as some employment systems are concerned. I mean, we spent the last 5, 6, 7 years be debating on how much flexible the employment systems should be in order to improve and maximize the economy, and in order to have a remedy to the negative effects of the financial crisis. Well, now we are maybe in the end, and we realize that despite most of the states and most of the lawmakers actually accepted the indications coming from the agenda, mostly also from the European Union. Maybe employment system and flexibility in hiring, either hiring or dismissing, have really few or maybe nothing in common with finding a remedy to the financial crisis. So, but in the end, in the meanwhile, we have an employment system which is completely different from before. I'm not speaking just of Italy, but I think that Italy is an extraordinary example of it. And in the meanwhile, of course, employment has changed. Technology tool give access to a lot of new way to think and to perform the job, and so we don't speak anymore about flexibility, but we speak about the new forms of employment. Well, first question which I have is if, and something has been said this morning in some of the intervention, is if it's really true that we speak about new forms of employment. I mean, in Italy, for example, a very well-known scholar and also politician, actually, and also lawyer in labor law, Pietro Chino, it has been more than a decade that he's saying that there is an apartheid in labor law between protected people and non-protected people. Maybe this problem of fragmentation, I heard many times this morning, fragmentation of employment market is really a problem, is really our problem. But maybe it's not the new one. Of course, the drivers of Uber, the riders of Foodora, or the shopper of the provider who comes to with a bag from the supermarket to your home. Of course, this kind of employment solution of jobs did not exist before, but still, what we are facing is something that is still the same. The fragmentation of the job market between protection and non-protection of workers. But still, the point is that the employment systems we have now is a system that we barely do not know, and we do not know the possible interpretation of the same employment system. And again, the Italian example is extraordinary, because after, I think, from 2012, 6 years of really dismantling of the employment protection with the Fornero reform before in the Italian Jobs Act, now we have a system that we do not know and we do not know how to interpret. So we are now facing the question and the problem of the selectivity of the protection, and how to select the people, the worker who deserve a protection, but actually we neither know the tool and the interpretative possibility that the new legal system, which has been forced, is new, has provided. So in this context, actually, I think that drivers, riders, shoppers, crowd working is very important, and also on a mediatic perspective has a significant impact, but still it's the tip of the iceberg. But the iceberg is something that we already knew, have been knowing for a lot of time. So now the point is, which is the role, our role, the role of the jurist and the people who needs to interpret the law in this context, because sometimes and somewhere there is a kind of mission of the scholar or the judge to find the subordination paradigm everywhere. We were discussing and quoting before the case of the labor commissioner in California. This was this is explanatory on what I'm saying. I mean, in that case, the judge found out that the minimum elements to recognize subordination in the driver of Uber, but even if it's very difficult to do a unique discussion on this matter, because Uber operates differently from one country to another country. Also Deliveroo, also Foodora, all these companies, even if they have a business model similar, they decline differently their business model depending on the specific national employment systems they have to deal with. But still, more or less, the substance of the business model is still the same, and irrespective of, notwithstanding, we have a very different interpretation worldwide on if there is subordination or not with the driver of Uber or rider of Foodora and so on. For example, in UK also the court extended some protection of employment to these gig economy and workers, but they speak about workers and not about employees, for example. In Italy, we have two cases, and actually by using substantially the same arguments that have been used more than 20 years ago with the Pony Express matters, I mean the riders with the motorbike, they say that they are not subordinate employees. But still, the question is if also the aim to find out the criteria and the minimum requirement for subordination is a solution to the fragmentation. If the subordination is a model which is consistent with our new era and our current age. And okay, I called this intervention an irreversible cultural gap, because maybe, for what is my understanding, continuing to speak about subordination in the traditional way of thinking is not really the correct way to face the problem. It's not anymore Fordism, it's not anymore post-Fordism. The new economy is, but not new of the last 5 years. It's I think more than 10 years and maybe 15 years and 20 years that we are dealing with some problem, with the problem that labor law is still built like if we were all blue collars in the production system. So but I think we have said also this morning that the aim of this debate between us is to lay a lot of questions and avoid to give sure answers. But I think that the role of the jurist in this perspective shall be divided and split into two different directions, but none of this direction shall be avoided. First direction is interpretation of what law is now and how can be interpreted. And I would like to remember also, by making reference to somewhat that I heard lastly this morning, that the role of the person who provides his interpretation is different between the different legal systems, and I mean civil law systems as ours and Italian, French. The judge is la bouche de la loi and cannot go over what the law says. And still the judges understand that the systems is not updated, is not consistent, and I think that an extraordinary example comes lastly with the decision of the Constitutional Court of Italy, which actually condemned, which actually declared that the last reform, the most important labor last reform in Italy, was unconstitutional. I will avoid an example on how to interpret Italian laws, since this is not the right context and would be a discussion also between us three. And I will move and switch, and I'm going to finish my intervention to the perspective, to the second perspective that the jurist, in my opinion, cannot have avoided to pursue in this context, which is a de jure condemned perspective. There is a big fight between scholars in Italy in this moment, between people who think that the systems is okay, categories are not old and can be used also today, and people who think that, as I am actually, who thinks that there is this cultural gap. In the latter position, we need to find out some criteria to solve the point of the fragmentation of the labor market and the point of the selectivity of protection. I do not have now anything innovative to say. I was discussing before, but I think that it makes some sense, a proposal who comes from a very well-known professor in Venice, which is Adalberto Perulli, which is speaking actually has been speaking for some years, but strongly in the last period, of using the criteria of the economic dependency to pinpoint people who deserve protection. After having pinpointed and selected the workers to be protected, then, and this is again a de jure condendo perspective, it shall be understood which kind of protection have to be extended to people. I conclude simply by saying that this is a very difficult moment, and that we have a lot of people and workers who work hard and who are not protected, and who are going in a few decades to be without, still even more without protection, without pension, without sickness protection, and I think it's the duty of all of us to find a solution. Thanks.
Thank you very much for a very interesting speech. Rzeczywiście jest to bardzo interesująca problematyka. Te nietypowe formy zatrudnienia wymykają się spod regulacji prawa pracy i dzisiaj wielokrotnie już była mowa o zatrudnianiu pracowników różnych platform cyfrowych i rzeczywiście tutaj tych elektronicznych agencji tymczasowych. Rzeczywiście tu jest wielki kłopot i trzeba się zastanowić, tak, jak tę kwestię rozwiązać. Ustawodawca powinien ingerować po zatrudnieniu. Wydaje się, że tak, ale nie zawsze bym tutaj się poszukiwał mimo wszystko stosunku pracy. Tak? Raczej wydaje mi się, że należałoby tutaj iść w kierunku tych autonomicznych form zatrudnienia, gdzie jednak no, ta swoboda podejmowania decyzji co do świadczenia usługi w danym konkretnym momencie no jednak jest, no, wydaje mi się, że większa niż na gruncie stosunku pracy. A to oczywiście jest to dyskusyjne. Myślę, że jeszcze będziemy o tym mówić w trakcie dalszych obrad. Prosiłbym może o wygłoszenie kolejnego referatu. I'm asking for a paper Giuseppe Antonio Reccia, University of Venice in Italy, the gig economy and the qualification dilemma from the judicial to the theoretical approach.
Dzień dobry. I'm afraid my Polish ends here. But I would like to thank you for inviting me, for being here. And as already been mentioned, I will follow in a way of what my colleague was already talking about, because my focus is on the gig economy and the qualification dilemma, which for the law scholars is the fundamental dilemma, not only because we also start almost every study by saying in which box we put things, but also because we discuss what consequences come from putting things in those boxes. So just to go very quickly to some few introductory remarks, gig economy may seem still exotic somehow, and depending where you are, obviously, it may be more than in other countries. If I was speaking in UK, no one would need to be explained what gig economy is, but not always is the same, not always is like that. Surely it's an accelerated process of using work, that's for sure, but it's not only work in that respect, because we're also dealing with a way of providing services which don't necessarily imply work. Airbnb is one very good example of that. So there's a first trait which has to be underlined, which is the great heterogeneity of the phenomenon. And I was thinking earlier about some of the remarks that some other colleagues were saying, and it's almost quite ironical that we're trying to put things into the gig economy box. It's almost like if 100 years ago someone wanted to describe employment relationship by the fact that we were using a typewriter or a pen rather than something more advanced or technologically advanced. So, but when it comes to work and when it comes to labor, obviously we do tend now to agree at least on these two main separation between crowd work, so the worker actually works online and never leaves his computer, never leaves his app, but it's giving work, it's providing work, whatever the client may be, and that obviously gets called cloud work, crowd work, portfolio work, but we're all still dealing with more or less the same type of phenomenon. And what is instead the so-called gig economy, the minimal work economy, which is what I'm going to focus on today, in which actually there's nothing new apart from the technology, because the work which is provided is dog sitting, food delivery, so old jobs, but just done in a very technological way. Our perception of the gig economy also have changed. These are obviously two famous covers of The Economist, just 1 year apart from each other, and what seems to be very pleasant in the first, a year before, doesn't exactly look the same a year later. So the idea of the house in which you can sit and provide work becomes workers on tap just a few months later, and this is obviously the type of problems that we have to deal with. The other problem has already been mentioned this morning by our German colleague from the Max Planck Institute, is that the data are not exactly telling the full story, because there are not real, strict, available, certified data. So if we have to believe what is being investigated in the last couple of years, we know that at least 2–3% of the European population, if we want to look at that, but obviously the percentage could change over countries and over continents as well, but provide work in that respect. And also it's interesting to notice that an increasing number of them provides work full-time in that way, which is obviously a problem. But I would say that apart from the actual numbers, the problem is the domino effect of what we call uberization. And a sociologist, Peter Fleming, was writing that the socio-economic logic of the uberized economy not only exploits workers directly, but also creates competition with so-called standard workers, because they are in competition of providing the same service for less money. So the domino effect of the gig economy will extend inevitably as a consequence onto the standard work, or what we are not considering right now. So new forms of employment will inevitably affect old forms of employment as well. When it comes to employment law, of course, as my colleague was already pointing out, the gig work, and I'm focusing on that specifically, is facilitated through technology, but with the idea or with the misconception that the platforms is just a tool, an instrument to make contacts between who provides work and who is the client and who's getting that service. And their business model, although varied as it can be, hides exactly that point, hides exactly the role and the responsibility of what could be an employer. I'm not saying that every platform is an employer, but surely if there is a certain type of employment relationship, it's put under the carpet. Also the shifting model that these platforms work has pushed some of the scholars, Jeremiah Prussell is probably the most famous of them, to think of a different way of thinking out of the box, just to keep on my metaphor, in how to find the employer. And is fascinating, but I think unfortunately not very useful way of dealing with it, is divide all the function. A worker supplies retribution, a worker has to guarantee job protection, has to give job security and health security. So if we split all these functions, we can find different employers. It could be the platform, it could be the client. Unfortunately, that in courts will never work, because you can't call all the people that are involved in the process hoping that one of them is going to be the responsible one. However, as fascinating as it is, and as much as the platforms do try not to stress the possible employment relationship, status does matter for what we were talking about earlier. And in this respect, obviously, it's a meeting between the old and the new. Our legal system are all based, mostly are based onto a bipartite taxonomy: employment, self-employed. Or sometimes, like in UK, a tripartite taxonomy: employee, worker, self-employed. Whatever is the case, there's one trait which is in common, and it's what I call the all-of-nothing philosophy. If you belong to one of those categories, you get generally all the protection that the law guarantees. And if you belong to the other one, there's not enough protection. If that wasn't the case, probably the qualification dilemma would not even exist. We would not worry if a gig economy worker is employed or self-employed, because we would grant him at least a certain number of protection and of standards, which instead we don't, because of the boxes that we have created. So the theoretical approach, unfortunately, crashes onto the case law, and which is what I'm going to quickly go into overview. It's very interesting to talk about theoretically of these things, but then what happens when a gig economy worker gets injured and has no insurance, or works for less than €5 per hour, and he thinks that maybe that not be enough? That's where case law begins, and that generally is what judges are faced with: workers which demand to be considered as employees, or at least in the tripartite taxonomy as workers instead of self-employed or self-independent contractors. I won't go into all details. I take the liberty to say there is a presentation. There will be obviously a paper, written paper as well, but I'm going to trade a few common traits between what's already been available to the case law, and I'll consider UK, Italy and Spain. 3 different countries, 2 countries with a similar system, obviously Italy and Spain, and one with a common law system instead. But I start with UK because obviously the gig economy has become much more of a problem over there, and the case law is already producing numbers which are not just the occasional decision. We count at least 3 decisions that I'm going to quickly go into. And the first one is obviously the very famous Uber case. The Employment Tribunal of October 2016, which was confirmed in the Appeal Tribunal of last year, which basically states Uber drivers are workers. So they're not self-employed, as the platform was actually stating. But what is interesting is actually why they are workers. I mean, which grounds the case is based on. I'll go quickly through some of them. According to the judges, Uber does not work as a platform which connects drivers and customers, but it is itself the person, the entity, which interviews and recruits drivers, which imposes a variety of conditions, which instructs the workers how to do the jobs, and controls their performance, obviously by the rating system, reserves the power to amend the driver terms unilaterally, which is a form of not only control, but of really directorial power over the contract itself, and controls key information and so on. But in general, the power that the platform has over its drivers just show that it's not just a tool of getting in touch with one another. A similar solution has been actually given in the most recent of the UK cases, which quite ironically does not concern gig economy at all, because it's the case of the Pimlico plumbers, and they do a very old job, which is plumbing, but not through a platform, but through a company which works like a dealer of these plumbers, who are all self-contractors. So they are available 24 hours, but they have their own van, they provide their own services, But actually, in a case which started in 2011, and it was considered since the beginning like the pivotal case of gig economy in UK, because the similarities are extraordinary. Finally, the Supreme Court, June this year, has stated that they are workers as well. Not all is good or all is gold, as you may think it is, because then you have exactly the opposite decision in similar cases like the Deliveroo, in which it wasn't in front of the tribunal, it was in front of a central arbitration committee, but it stated that because in this case the riders are able to substitute each other, so to take their shift from each other, they are free, and hence they are not workers or employees, but they are self-employed. Again, it's not the end of this case either, because it's been recently ruled against, but on the basis of human rights. So it shows how difficult sometimes it is even to extricate the situation through what we normally use as juridical tools. Quickly going into the other two situations, I chose Italy and Spain because they tell the same story but with exactly opposite results. As was already being suggested, in May this year, the Turin Tribunal decided that Foodora riders, which are food delivery riders exactly like the Deliveroo or the Glovo in Spain, they were self-employed. They were not subordinate workers, they were not workers in the most general sense. And what is interesting is how that is justified. And that is justified on the basis that there is a freedom on each part to choose to work or to choose to not accept the work offered by the riders. So the workers are able to offer the availability and to put themselves into possible slots, but not to accept it eventually. And the platform is free not to put them in the slots they want. That normally would indicate something else, because that would indicate a directorial power. But in this case, the freedom on both parties convinced the judge that we were talking about self-employed work. Every other indication that would have stated otherwise, like the pay by the hour, the working hours required, and I'm just giving the most important ones, but there were many, many, many more, were not even taken into account. Not even the geolocalization, which is a way of controlling the performance itself, in a way which has never been available up until now, because as it was referred already, the judge used a reference in our system, in our case law, which was the Pony Express from the 1980s. So workers who delivered parcels on a motorbike with a radio transmitter. But in that case, the control was pushed or forced by someone actually switching on the radio and calling the driver or the rider, which is absolutely unnecessary right now, because you can control second by second where the driver is, where the rider is, and if he's doing exactly what he's asked to do. That is not even taken into account. Interestingly enough, Spain, on a very similar case, because Deliveroo does exactly the same service as Foodora, judged only a month later by saying they were not only workers, but they were subordinate workers. So they were in fact employees. And what is interesting is that the Spanish court takes into account everything that the Italian court has not. So the freedom is not even mentioned. What is really important is that the rider uses a program which is developed by the company itself, and without that program it can't work. The company as well decides which is the area in which a worker will provide work, and even if he chooses or she chooses not to work, she has to put himself into the available slots. So he has to integrate himself or herself into the organization. And finally, everything from how to deliver the food, within which time to do it, and what else, even how to behave with the client as already decided, ruled by the platform. Does it mean that we have reached a conclusion because the Spanish have opened our eyes? If only. As a famous case law in the US already stated, you know, sometimes dealing with the gig economy is a little bit like facing a square peg and being asked to choose between two different round holes, so it's almost impossible. But I think it's almost impossible because we are actually probably using the way that we are dealing with a normal differentiation or the bipartite system between subordinate and non-subordinate, employed and self-employed, by a very old way of interpreting those concepts. If we want to update them, you know, I would say that employee versus contractor, employment versus self-employment is the equivalent of control versus autonomy. Every employment relationship, even the autonomous relationship, is not without control. And even the most subordinate relationship is not without autonomy. So maybe it's time to reevaluate those concepts. I've listed more than a couple, but I will just point out a couple, I promise, of questions of what is to be revalued. One of the common traits, as I was pointing out earlier, is the control, and how is the control is exercised by the company. And do we still think that the control has to be somehow personal or human, when actually the algorithm is more controlling than we could ever think of? And another thing, again in these cases, it's always one of the points that all these workers provide their own car, provide their own bike, they have to have a phone, otherwise they won't be able to work. And that, when we're talking about subordination, is what we call the alienation of the means of production. You don't own the machine. But what is actually the machine that you don't own, if it's not exactly the application that you use to work, and not the car that you work with? So, finally, I will come to my conclusions. As we already seen, and it's becoming like a trend this today, and it will probably be the same tomorrow as well. You know, the existing rules don't necessarily cover all the bases. We can update our way of seeing things, but even in that case, and this will be another common trait, pushing some of these workers towards employment instead of self-employment won't solve the problem. So, shall we go beyond misclassification, or even shall we just give up about the qualification dilemma? I end up exactly with the opposite of what I started, you know. Let's go beyond it, in a way. And I would just like to, obviously, there are some possible ideas written in that slide, but I would like just to point you to the last one, which is a quote taken by two English colleagues, again, UK, Mark Friedland and Nicola Contouris. And I pride myself because Nicola Contouris was a colleague of mine in Bari University, so in Italy, where we both started. They said, and they said it in 2011, way before we started talking about these things, the function of labor law as a whole is one of maximizing the dignity accorded to workers in personal work relations, and these are all personal work relations, optimize their capabilities in and through those relationships. So it's a question of dignity rather than qualification. Thank you so much.
Thank you very much. Yes, of course.
Thank you, Giuseppe. Hello. Thank you, Giuseppe, for a wonderful presentation. A couple of questions. You pointed out to a number of contradictory rulings I wondered if someone has thought about taking this matter to the European Court of Human Rights.
This is what is already happening with the Deliveroo case.
Okay. And has a ruling been issued?
We haven't yet. We don't have it yet. But I mention it in. Normally, I write it very, very small, like like the clauses that you don't want to read in a contract, and this is it. So when actually the Central Arbitration Committee, oh, have you? No, I was going back. Okay. Oops. No worries. I'll go. I'll go to it. That's it. So when the case that was brought to a Central Arbitration Committee was, do we have a right to collective agreements, to strike, which is as a consequence, that's where the status starts from, and then it stems into collective rights, social protection, and further on. So when the industrial workers of independent workers of Great Britain, which is the autonomous trade union protecting gig economy workers, applied to be recognized as a trade union within Deliveroo, they were rejected because by English standard you have to have a certain number of members and other rulings, but mainly because as independent workers, because they were free to substitute each other, they were not recognized the right to collective agreements and to strike. Now, on the basis of the human rights declarations instead, and also on the human rights grounds in within European Union.
Not to mention the ILO convention.
Exactly. That right is recognized regardless of your status. Right. So you have the collective right to bargaining, you have the collective right to strike, whether you are employed or self-employed. The tricky thing, maybe you know it already, but coming from US, it could be a different viewpoint. The tricky thing is that because our European Union is based on the free trade system, a collective right could become some sort of negation, some sort of denial of the free trade, because it's somehow forcing the free trade itself.
No, but
I know, if I see some faces, I recognize immediately what's wrong with it. If we form a joint committee that impose onto someone else how much we need to be paid, that's a force of the freedom of association. That's a force, sorry, of the freedom of trade, unless you are an employee, in which case your weak role status allows you to form that kind of coalition. But within companies, it would be a cartel, it would be a monopoly. If companies, like in European jurisdiction, in the European Court of Justice jurisdiction, the opposite of worker is not self-employed, is assets, is a company. So if you're not an employee, you are a company. And therefore, if you're not recognized as a subordinate worker, what you're forming through collective agreements, what you're forming through strike, is a cartel, a denial of the free trade principle.
Yeah, one quick point, if you will please permit. If in international law it's well settled that if there is a conflict between domestic law and an international law, then the international law trumps the domestic law, particularly if the member states have ratified the convention.
Yes,
now,
yes
that
and
could
no.
that could be invoked in order to rule in favor of the workers.
Again, the interpretation, unfortunately, in old Europe of all the principles that we're talking about have always been influenced by the idea that they were given to employees. So the qualification dilemma that we were starting from is still urgent, is still burning, because as much as we want to expand that idea, is always connected to the idea that you are the weak role in that contract, that you are the weaker part of the obligation that comes from whatever contract you sign with the platform. And that affects everything else.
Dobrze, dziękuję bardzo. Thank you very much. Myślę, że jeszcze być może wystarczy czasu na dyskusję. Poprosimy kolejną osobę, panią doktor Natalię Gerasimczuk z Politechniki Rzeszowskiej. Telemedicine as a future perspective of healthcare system. Development of implementation strategy basis on the project marketing approach.
Good evening to everyone. Thank you for organization of conference for invitation. I'm here for the start. I'm here as an economist rather than a lawyer. However, I have a degree. So my presentation is dedicated more to the medicine, telemedicine, and how it organized. And it would be allocation well, from more like not European Union countries such like Ukraine. So I will have a little talk about telemedicine, its main aspects, and its. From the start, I would like to tell that it's interesting saying that that day that the telemedicine was adopted and recognized, it dies and became simply medicine. And this is true, really. Telemedicine, that is provision of medicine services in the two cases. First, it is very slow medicine, and it needs to be put in the distant area, or it is where it is some needed to be added, some functions, some knowledge, and so on. There is a word which comes from Greece and so on, so that's simple things. And the big idea about this system, it is stop being just something new, something for not very many people, and became a normal practice in our life. And because of new technology coming in our life, it's from the 70s, is present in our life. First it was just phone calls, just connection between your doctor, like a personal base level. Now it is that some Google concept of the telemedicine, that is some aggregation of a system of specialists, of hospitals in some new organization, like telemedicine company, and it is present in the United States of America. And there is two different types of telemedicine, and it could be combined, but really the most classic, it is real-time telemedicine, like phone calls, like Viber chats, like video conference, and going forward, then at first the data is collected and then sent, and then have it, the specialists have the time to look at it and give their conclusion. Real time has its features, and it could be traditional, understood, and it has its good points. It is quickly gained information, and not negative points of real time. It is that sometimes for the protection of the doctors, it's very hard to store the all creatures' information and have a record of what have been done, because it's simulated. And going forward, it is then doctors has more time, and it's more protocol-based type of medicine, and its features, and it's providing less. The minus is the lack of time. That could be months period. However, it could be provided more up to present protocols, medical protocols, and of course, well, it's how it happened in practice. Doctors like very much the second point. So application, there's many, its future direction is now walking direction in countries like United States of America, where it is, there was, were pioneers of this. In our country, well, in Poland, in UK, I know for sure it is only starting. However, it is trying on the telepathology. Such oncological diseases are very good, have very good practice on this telemedicine point. So the most promising what could be done with the telemedicine and why it is different from the typical medicine. At first, it is an interesting case about disaster management. It was an interesting case that in Texas was prohibited telemedicine in the United States. And then it came to the very, nowadays in America, you know, it's a catastrophe. In telemedicine companies provided their help. So they gained the trust of the people, and Texas cancelled that law that prohibited telemedicine to work. The system medicine, it is the first step to help to the people. In the critical, then with no time, no hands, but there is a specialist who could help at least those low-level medical personnel who could take this advice. Also, healthcare laboratory, it's then you get out of the hospital because, well, no money to be in hospital for the months, but you need to help what you should to do, how to you should help yourself in your home. So it's like a provision of less expensive medical help to your home. Also very important for the remote consultation and pregnancy monitors, because the young mothers, future mothers, are very touchy with these things, and they need constantly like consultation for their gynecologist and their doctors. It could be a stupid question, but they need this service and they wanted to pay for it. Childcare pediatric, this is the most controversial part of the telemedicine. Because it's very hard on the medical protocols and very high risks. However, due to the medical point that the children have very quick time from the first symptoms to the very difficult situations, so this like disaster medicine looks like. Second opinion, this is like 70% what is used in telemedicine now in Ukraine. So it is not urgent, but it's very, very in touch with the people who sending their documents, their slides to the Israeli clinic, to the German clinic, especially with oncology. And the medical education also is like the future, this video conferences and sharing of opinion between the doctors. Advantages of a telemedicine is now those, however, it would be going further and more. It is, of course, for me as economist, cost saving. The point is that doctor, it is a profession, and that for the society to raise one good doctor costs very much. And in order to use this knowledge collected through the years, and was calculated from the United States doctor how many years he studied. It is 21 years. And of course we need to use this asset of the society the most extensive way. And one of the ways is to share its knowledge, of course, on the payment based, because every work should be paid. However, we not limited to the 24 hours of this person life. We could use it. And of course it is, for me, for this user, it is avoid unnecessary transportation, because time in transportation between medical advising the patient could be critical, and it could be impossible for some cases to bring the patient to the doctor. Well, it is also many more, but we don't have much time. So, and also resource utilization. There's a lot of which could be done by the telemedicine, by the new equipment, and save us time and money, which could be crucial in some cases. And with the medicine, it connects with the health, life, and it is of course crucial. Early intervention, one of the points that we could collect the data, and then we could have a database of this patient with this new equipment, and of course we could the doctor who collect would send some his thoughts and take a second thought on the some analysis which is bothering it, some maybe points. Then it could help a lot, especially with oncology, to stop the disease on the early stage where it could be cured. And avoid necessary transportation, as I said, then it is not necessary. Sometimes 60% of the problems which is voiced by the patient could be solved on local hospital. Not going to some center, some big city, it could be consulted and takes less time and money and transportation expenses. Community-based care, that is, for my opinion, if we have these big centers in big cities and we have a local hospital and with telemedicine, we can grow up the local community quality of life. So living in your territory and having having these possible services possible to take on the level of big city, make the life in the rural areas more comfortable, because you know that you would be in the good hands even if you live very far away from the big city. Medical education, this for medical growing up the professional skills. Cost saving, of course, that I would take like 10th time, because it's really cost saving. And there is a principles which is coming now in our life about this type of medicine. If it was previously just like for fun, now we are going to the stage, then we are building, should build infrastructure. Well, for now, there's a lot of countries which, first in this infrastructure building, it is that it is recognized, at least, by the law. And infrastructure building of medical telemedicine is mostly based on the achievement of IT industry, which we have. We have a speed internet, we have a lot of programs to choose between for the using in telemedicine services. We have protocols which could help us in this job, and well, it's possible now to start a provision of infrastructure. And one of this infrastructure building is based on the legal acts which have implement us on this telemedicine, the rules of the game. Because this is a medicine, of course, we have a lot of obligation to the patient and so on. But the telemedicine is based on those same principle as the traditional medicine, so nothing than exaggerating you could be applied. Okay, what I would like to tell one saying very good, that in just a few years we have a great lab from the just Google asking what to do to the big sector of the economy, which has more than 150 millions of dollars per year. So what actually has during this program, we have a lot of sorry. So I would like to skip to top five opportunities which could be presented, and its worked already show its efficiency. And first, it is geriatric practice. For we have problem, young people going out and leaving their old parents. And this is a very good share of Western medicine services. Then I am as a daughter buying a package of a service for my, for example, father or mother. So they would be attended, and I would know that they are medical attended. I have this information on my laptop. I know what this morning he was his indicators of health and so on. This is very huge part of the market. Second, it is telepsychology. So we sometimes have some small times for ourselves, and this works. Very many psychologists are coming out of their cabinets to the internet, proposing their services. Telemonitor, it is thanks to new technology, to new things in medicine, we could use this part. However, it is very costly by investment. And intensive care unit could be presented to the good professionals who could see the patient and see the not one intensive care unit, but more than one in one time. And teledrome, which is one of the 60% of melanoma is checked through the internet, and in there something we are not sure about, and the doctor tells us what it is. So there's a lot of no. What I want to tell about the topic of the concepts, one of in Ukraine, we have very huge IT technologies workers who works independent, and on their steps are going medical workers with their knowledge, with their skills, and they are very, very low fare. So for them, as for the workers, they could go up and have their niche of this salary market. They could sell their service. The question is, should they work as independent doctors, which is just like telepsych, the psychologists could be said. However, in law, by Ukrainian law, they want to implement telemedicine on the basis of existing hospitals, so taking some part of a doctor's time to this kind of services. What does it good for does good for society? Because it is sure about quality. It is employed on the rules which is come to the protection of this doctor, and of course he is applying international protocols and so on. However, the points about payment. So many hospitals in the United States combine telemedicine and medicine. However, there is a second group of companies which is provide totally independent from the hospital telemedicine services. And this would be, I think, case for Ukraine, because the Ukrainian doctor would not like to pay very much to their budget, but as it practice show, like our IT programmers. And telemedicine give them possibility to do this. So they work for themselves, and they have ability to come out of a standard traditional work relations between the clinic and the doctor. Of course, there is some risks for the customers, but well, we all entrepreneurs take our risks. Thank you very much.
Dziękuję bardzo. No, problematyka telemedycyny widać bardzo interesująca. Rzeczywiście to zjawisko ma daleko idący potencjał i wiele zalet, natomiast no, wydaje mi się, że z punktu widzenia prawa pracy, no to tutaj największy problem i pytanie dotyczy tego, no, na jakiej podstawie, tak, będzie realizowana ta relacja, czyli czy to ten lekarz będzie pracownikiem, jak rozumiem, czy będzie zatrudniony na podstawie umowy cywilnoprawnej, czy będzie samozatrudniony, no bo nie wyobrażam sobie sytuacji, w ramach której taki lekarz mógłby świadczyć usługi na zasadzie Ubera, tak? Czyli powiedzmy gdzieś tam na platformie, no bo tu się pojawia jednak mimo wszystko kwestia odpowiedzialności za te usługi, no bo co innego jest, jak powiedzmy nie dostaniemy pizzy na czas, prawda, albo nie zostaniemy przewiezieni w jakieś określone miejsce, natomiast no, inną sytuacją jest to, kiedy powiedzmy na skutek zaleceń udzielonych przez kogoś tam, jakiegoś tam lekarza X, prawda, możemy na przykład stracić życie lub zdrowie, tak?
No tak.
Tutaj mówimy o jakiejś onkologii, prawda, takich poważnych tematach, a więc no, wydaje mi się, że tutaj z punktu widzenia form zatrudnienia to raczej wchodzą w grę tylko te klasyczne formy zatrudnienia, które są znane i powszechnie akceptowane.
No, u nas było takie badanie i dużo jest no, badanie pytań Google. I wyszło tak, że jak boimy się, że za to zatrudnienie oficyjne, żeby ten lekarz był odpowiedzialny, a mamy gdzieś za dużo, nie powiem, no to było to gdzieś do 100, no na 100 ludzi, 90 ludzi pyta wszystko, co się dzieje w internecie. Na różnych tych forumach, jakie nie są odpowiedzialne.
To jest kwestia odpowiedzialności, tak?
No tak. Teraz to się, jak się ten system no, w Ukrainie i w Rosji się robi, że hospitals, to no, duże kliniki, oni prowadzają to jako dodatkowy serwis opłacany.
Tak, czyli rozumiem, że ci lekarze są zatrudniani przez te
że oni
szpitale,
mają na przykład
jako ponoszą odpowiedzialność te szpitale za ten usługi, tak?
Tak, i no tak, żeby mogłabym tydzień być jak w klinice, potem wyjść z kliniki, żeby nie płacić jeszcze 2 tygodnie, mogłabym zostać i przychodziłaby do mnie siostra medyczna, robiła te wszystkie...
No tak, ale wtedy wiemy, kto odpowiada. Odpowiada szpital, który zatrudnia tego lekarza.
No, ale no, to jest tak, jak zgodnie z prawem, jak się przewiduje. Ale jest drugie, że dużo jest takich firm międzynarodowych, jakie proponują. Jakie są umowy? To nie jest bezpłatne, że $1000 kosztuje urządzenie, jakie się montuje w osiedlu i potem $60 na miesiąc to taka abonament, żeby prowadzić te i potem ten narzędzie, jakie za $1000 to się bada krew, tysк, ciśnienie, no wszystko to, co potrzebnie. I z jakimś, no, to jest najpierwsze dla starszych ludzi, jak jest chroniczna choroba, to są przeznaczony lekarz do tej choroby, no i to tak działa, że ja jako dziecko, no jak już dorosła mogę to opłacać i ja wiem, że moi rodzice są bardzo dobrze zaopatrzeni, chociaż oni mają swój szpital i tak dalej, ale to co do odpowiedzialności, teraz jest przyjęte to wszystko automatyzowane na tyle, że jest protokoły i ten, znaczy nie lekarz, a protokol odpowiada za skutki leczenia. No, protokol leczenia, że napisane co lekarz, jak w Niemcach. No tak, że lekarz jak widzi jakieś objawy, to on po prostu wybiera ten tryb leczenia, jaki jest napisany przez międzynarodową wspólnotę, już przyjęty i nawet nie bada, co jest no, w rzeczywistości, on po prostu przyjmuje protokol leczenia. To chyba taka automatyzowane leczenie. U nas w Ukrainie się nie jest takiego, ale wprowadzamy go.
Rozumiem, że nawet nie trzeba mieć kwalifikacji.
Nie, no, musi Pan mieć kwalifikacje, żeby po prostu wiedzieć, o czym, no, doprowadzić wybór, oczywiście.
Dobrze, dziękujemy bardzo za interesujące wystąpienie i poprosimy teraz panią doktor Iwonę Bielewę z Uniwersytetu Marii Curie Skłodowskiej w Lublinie o zaprezentowanie kolejnego referatu wybrane zagadnienia dotyczące nowoczesnych form zatrudnienia. Taka szeroka formuła.
Dzień dobry. Formuła tytułowa była bardzo szeroka, natomiast zostanie ona zawężona. Z jednej strony pod wpływem lektury przedmiotu, z drugiej strony pod wpływem czasu, który nas obowiązuje, także postaram się tak zmieścić ten referat, żebyśmy jeszcze mieli czas na dyskusję. Jednym z aktualnych problemów polityki rynku pracy jest uelastycznienie zatrudnienia. Istotnym elementem takiej elastyczności są nietypowe formy zatrudnienia, organizacji i miejsca pracy. Formy elastycznego zatrudnienia są elementem nowej polityki rynku pracy opartej na zasadzie flexicurity. Jako jeden z przykładów uelastycznienia zatrudnienia można wskazać tak zwany job sharing, który rozumiany jest jako zatrudnienie w niepełnym wymiarze czasu pracy. W Polsce zatrudnienie w niepełnym wymiarze czasu pracy niejednokrotnie postrzegane jest negatywnie, jako takie, które ogranicza rozwój kariery lub też takie, które nie daje możliwości zarabiania godziwych wynagrodzeń. Natomiast ważnym jest, żeby wskazać także pozytywne aspekty job sharingu, które coraz częściej są eksponowane. Wśród takich zalet job sharingu można by wskazać dość modną ostatnio równowagę, tak zwane work-life balance, gdzie job sharing, zatrudnienie w niepełnym wymiarze czasu pracy daje pracownikom możliwość dostosowania wymiaru pracy do ich pozazawodowych potrzeb, głównie potrzeb rodzinnych. Tu mamy na myśli głównie łączenie opieki nad dzieckiem z rozwojem kariery zawodowej przez rodziców, którzy korzystają z uprawnień związanych z rodzicielstwem. Job sharing ma także pozytywne aspekty łagodnego przechodzenia na emeryturę poprzez częściowe wygaszanie etatów, ograniczanie stopniowe aktywności zawodowej osób w wieku przedemerytalnym czy samych emerytów, tak żeby złagodzić skutki nagłego przerwania ich zatrudnienia. Job sharing ma także pozytywny wpływ na aktywizację zawodową osób, które nie mogą pracować w pełnym wymiarze czasu pracy. I tu mam na myśli m.in. osoby niepełnosprawne, które z racji swoich jakichś ułomności fizycznych i innych ograniczeń nie mogą pracować w pełnym wymiarze czasu pracy. Job sharing traktowany jest także jako element ograniczający bezrobocie i postrzegany jako takie uzupełnienie etatów, chociażby w wariancie częściowym. Praca dzielona jest także jednym ze sposobów na poprawę sytuacji ekonomicznej pracodawców, którzy ponoszą niższe koszty wyposażenia stanowiska pracy, gdzie co najmniej dwóch pracowników może tę pracę świadczyć. Jeżeli chodzi o uelastycznienie organizacji czasu pracy, to może mieć ona wymiar zarówno chronometryczny dotyczący długości czasu pracy w wymiarze dziennym, tygodniowym czy miesięcznym, a także chronologiczny, który dotyczy wyboru i umiejscowienia czasu wykonywania obowiązków pracowniczych w ciągu doby, tygodnia czy miesiąca. Innymi słowy, pracownik, oczywiście w uzgodnieniu z pracodawcą i tym drugim współpracownikiem, ma możliwość wyboru, czy pracuje 4 dni każdego dnia, czy pracują zamiennie co drugi dzień, czy pracują jeden w jednym tygodniu, drugi w drugim tygodniu, czy rotacyjnie co miesiąc. Wariantów jest bardzo dużo i to jest kwestia porozumienia, tak naprawdę co najmniej trójstronnego, czyli pomiędzy tymi dwoma pracownikami i pracodawcą. Job sharing zapewnia elastyczność zarówno w tym wariancie chronometrycznym, jak i chronologicznym. Jeżeli chodzi o genezę zatrudnienia dzielonego, ma swoje pochodzenie w Stanach Zjednoczonych. Tam rozwijała się od końca lat 60. XX wieku, natomiast znana była już z czasów kryzysu z lat 30. XX wieku. W Polsce job sharing jest formą może nie do końca popularną, ale funkcjonującą właśnie jako niepełne zatrudnienie. Nazywana jest też systemem pracy dzielonym, dzieleniem stanowiska pracy, podziałem miejsca pracy, czy też tak zwaną pracą dla dwojga. Pod pojęciem job sharingu w Polsce rozumie się obsadzenie danego stanowiska przez co najmniej 2 pracowników i dokonanie pomiędzy nimi podziału zadań przypisanych do tego stanowiska i przypadającego na nie czasu pracy. Cechą takiego zatrudnienia jest także samodzielny podział czasu pracy dokonywany przez pracowników, ale ze strony pracodawcy, co moim zdaniem jest kwestią mocno problematyczną, istnieje możliwość, i tu sporo przedstawicieli doktryny popiera takie stanowisko, możliwości nałożenia na pracowników dodatkowego obowiązku w postaci zastępowania współpracownika w momencie, kiedy jest on chory, przebywa na urlopie. I tutaj nasuwa się pewien problem, ponieważ pracownik po części staje się odpowiedzialny za tą organizację pracy, gdzie wiemy, że podstawowym obowiązkiem pracodawcy jest organizowanie pracy w sposób odpowiedni i zapewniający możliwość wykorzystania potencjału pracowników. Z drugiej strony też zatraca się jakby idea tej pracy niepełnowymiarowej, bo pracownik, który decyduje się na zatrudnienie w niepełnym wymiarze czasu pracy ze względu na to, że ma inne obowiązki, czy to związane z rodzicielstwem, czy też związane na przykład z prowadzeniem własnej działalności gospodarczej, nie bardzo ma możliwość zastępowania pracownika dzielącego z nim stanowisko pracy, wtedy gdy ten jest chory. Stąd ja kwestionowałabym możliwość takiego zapisu umownego, gdzie pracownik jest ograniczony i tak naprawdę przejmuje na siebie odpowiedzialność za zorganizowanie pracy w zakładzie i odpowiedzialność dotyczącą częściowo ryzyka pracodawcy związanego z chorobą pracownika. Jest to kwestia dyskusyjna, tak jak powiedziałam. Poza podziałem samego czasu pracy na danym stanowisku, job sharing może też dotyczyć podziału funkcjonalnego zadań, gdzie zakłada się uzupełnienie w wykonywaniu pracy przez pracowników, którzy różnią się pod względem stażu pracy, kwalifikacji oraz doświadczenia. I taki podział funkcjonalny bardzo często spotyka się w firmach zatrudniających programistów, gdzie operują oni na różnych systemach, a projekt, który jest realizowany przez firmę, zakłada wykonanie projektu na przykład w 2 systemach operacyjnych, gdzie programiści funkcjonują czy bazują głównie na jednym z nich i podział funkcjonalny zadań pomiędzy 2 pracowników gwarantuje takie skorelowanie prac, żeby docelowo projekt zakładał 2 warianty systemu. Job sharing występuje w 2 wariantach, w modelu amerykańskim i w modelu europejskim. Model amerykański dosyć kontrowersyjny w polskich warunkach, moim zdaniem możliwy byłby do funkcjonowania, ale tylko na podstawach cywilnoprawnych i tu znowu mówilibyśmy o ekspansji prawa pracy, ponieważ model amerykański zakłada przeniesienie częściowo ryzyka gospodarczego prowadzenia działalności przez pracodawcę na samych pracowników, co w zasadzie jest niedopuszczalne w polskim systemie. Tutaj w wariancie amerykańskim pracownicy przejmują wspólną odpowiedzialność za wykonanie zadań i jest to odpowiedzialność niejako zbiorowa za tą realizację. Oni rozliczani są z efektu osiągniętego, a nie ze samej staranności działania. Tak samo jak przed chwilą wspomniałam przy odpowiedzialności za zastępstwo w czasie choroby i urlopu, w wariancie amerykańskim także pracownik przejmuje tą odpowiedzialność i ma obowiązek zastępstwa swojego współpracownika. Z kolei w modelu europejskim zatrudnienie w pracy dzielonej odbywa się w pełni gwarancji praw pracowniczych i z opieką socjalną wynikającą z prawa ubezpieczeń społecznych, tak jak za pracowników pełnoetatowych i tutaj takiej odpowiedzialności rozszerzonej nie ma. Jeżeli chodzi o job sharing, możemy wyróżnić kilka form. Mamy klasyczny job sharing, gdzie pracownicy dzielą się stanowiskiem pracy pełnoetatowym i dzielą także realizację zadań. Job splitting, gdzie następuje podział etatu na dwa niezależne etaty, a pracownicy pracują samodzielnie i każdy na własną odpowiedzialność. Tak zwany job pairing, gdzie łączy się pola działania wcześniej rozdzielone i dotyczące innych osób, innych zadań, a w przypadku połączenia tej realizacji za całość projektu odpowiadają ci pracownicy, którzy przypisani są do stanowiska. I tak zwany job level sharing to już zespoły pracownicze z co najmniej 2 osób składające się, które są powołane do realizacji zadań zakładających ścisłą współpracę co do informacji, sposobu pracy, czasu pracy. I tutaj przy tym job level sharing dość popularne jest funkcjonowanie takiego zespołowego funkcjonowania właśnie wśród pracowników wysoko wykwalifikowanych, między innymi informatyków, programistów, czy też to dosyć nowatorskie rozwiązanie, ale część kancelarii już też tak funkcjonuje, że właśnie w oparciu o ten job level sharing i oczywiście taka kancelaria musi być przygotowana informatycznie do takiego zadania. Są już programy, które rzeczywiście to umożliwiają, gdzie są przypisane role w systemie, gdzie są przypisane foldery, zadania włącznie z pismami, gdzie nadzór nad tym wciąż prowadzi pracodawca, aczkolwiek jakby projekt jest jeden, pracownicy pracują wspólnie, tylko odpowiadają za częściowe wykonanie zadań. Jak stoimy z czasem, panie profesorze? To już tak, konkluzja. Wskażę tylko akt prawny, który, na podstawie którego istnieje dopuszczalność zatrudnienia w formie job sharingu również w Polsce. To jest dyrektywa Rady 97/81, która zawiera porozumienie ramowe dotyczące pracy w niepełnym wymiarze godzin, a także konwencja Międzynarodowej Organizacji Pracy 175 z 1994 roku w sprawie pracy w niepełnym wymiarze pracy. W polskim systemie pomimo projektów kodeksu pracy nie doczekaliśmy się jeszcze regulacji job sharingu, ale tak jak wspomniałam, jest to możliwe do zastosowania w oparciu o możliwość ograniczenia zatrudnienia do części etatu. Podsumowując, chciałabym zastrzec, że job sharing mimo swoich zalet nie jest dla każdego i to zarówno nie jest dla każdego pracodawcy, jak i nie jest dla każdego pracownika. Po pierwsze, w job sharingu ze względu na konieczność dość ścisłej współpracy między pracownikami powstaje możliwość konfliktów i to dotyczącego wszystkiego, od podziału czasu do podziału zadań i odpowiedzialności za te zadania. Job sharing zakłada dużą samodzielność pracowników, dużą odpowiedzialność, no i umiejętność pracy zespołowej. Jestem też przeciwna wpisywaniu w job sharingu jako formy właściwej tylko do stymulacji grup słabszych na rynku pracy, czyli osób wychowujących dzieci, czy też wyłącznie bezrobotnych, dlatego że w sytuacji osób wysoko wykwalifikowanych job sharing może być ich świadomym wyborem, takim, który daje im właśnie możliwość zachowania tego work-life balance, równowagi między pracą a życiem osobistym i niejednokrotnie przy zwłaszcza tych wykwalifikowanych osobach poziom zarobków jest na tyle godziwy, że nawet przy niepełnym wymiarze czasu pracy i ograniczeniu proporcjonalnym wynagrodzenia możliwe jest ich funkcjonowanie na dobrym, wysokim poziomie. Dziękuję.
Dziękuję bardzo. The last presentation, Mr. Nailul Amadi, Universitas Gadjah Mada, Indonesia. Mrs. Go Live have an on-demand lifestyle service forms a new kind of employment in Indonesia. So,
Okay. 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 Good afternoon, ladies and gentlemen. My name is Nailul Amani, as you can see there. I'm from Indonesia. It's quite far from here, 24 hours journey. And I thought that I'm the only speaker from Asia here, so I want to bring you... Okay, sorry. I want to bring you all to Asia today. So it's really exciting. It's really an honor for me to share the panel with you, with all respected scholars today. So what I'm gonna talk about today is quite relevant with previous session, the new form of employment in digital era or any digital age, because the object of my research is digital platform, the biggest on-demand mobile platform in Indonesia right now. So my title of presentation is Go Live, how an on-demand lifestyle service forms a new kind of employment in Indonesia. First of all, let me introduce what is Go Live. So Go Live is part of Gojek. And so what is Gojek? Gojek is the first company in Indonesia that provides mobile platform that now being used by most Indonesians for every basic needs. Gojek is established in 2010 with only 20 drivers, and the first concept is ride-hailing service, just like Uber and Grab. Ride-hailing service with 20 drivers only, and now it evolves. Yeah, 1 billion drivers. Billion is 1 billion, yeah. 1 billion drivers. It's that what? Yeah, because in Gojek, it's not only ride-hailing service right now. It's all basic needs in one company. You can deliver food, groceries, moving company, and what is that? You can, and what I gonna talk about today is Go Live. You can do massage like in beauty salon or spa, and automotive, anything. There's a joke in Indonesia that you can live, you can still alive inside your house without make any steps outside your house if there is Gojek around. Because every basic needs provided by Gojek in Indonesia. In one company, it's a monopoly in Gojek. In 2008, there are 18, more than 1 billion drivers, 19 services, and it served in 50 cities. And the partners grew 346.2% in a year. Partners here means not only the driver, but like merchant, groceries, shop, etc., restaurant, etc. So this is the Gojek effect. I don't know if Poland have this kind of things, because I use bus in Poland a lot and it's really useful. I don't know, maybe Gojek rapidly success in Indonesia because public transportation in Indonesia is not reliable. It's unsafe, let's say. That's why people make Gojek like the best alternative for public transportation. So that's why it rapidly success. So for the Gojek Gojek effects, as you can see here, it contributes 8.2 trillion per year to the Indonesian company through drivers' income, and 1.7 trillion per year to Indonesian company through partners' income. And of course, like any digital platform, it provides employment for the highest group of unemployed labor force. And for full-time driver, it reported the income more than national minimum wage. That's how Gojek became the only company that provides complete service in one digital platform. Of course, but Gojek company position their driver as their partner, not their worker. It's like any other digital platform you use. And for bonus, rating system, suspension rules, termination of contract, not as result of partners negotiation. They call it as partner, but the rules, it's decided unilaterally by Gojek company. And because it cannot be defined as employment relation based on Indonesian labor law, there's no prevailing law that can protect Gojek driver at all. Because based on our Indonesian labor law, because we are a civil law system, we have a codification here. In Act 13 of 2003 regarding manpower, Indonesian labor law, it governed decent work, a minimum wage, working times, overtime wages, etc. And employment relations defined as a relationship between an entrepreneur and a worker based on an employment agreement which deals with aspects relating to the job, the worker's wage, and orders or instruction. Based on this definition, there's nothing Gojek can go there. Like, this is not relationship between, they're not entrepreneur, they're not worker. They say that it's partnership, and there's no instruction or order at all. They say it like that. Okay. So they promise flexibility, but when we talk about flexibility in Indonesia condition, that there are many unemployed workforce. So when we talk about flexibility, it's more like nonsense, because they won't make it as side jobs, because they will make it as main job. Like reported here, 87% of Gojek drivers make Gojek as their main job. And 85% of Gojek drivers is senior and junior high school graduated. It's unskilled labor. It's reported in 2017. And then let's see how Go Live event. So that's Gojek, and now we can go to Go Live, the emergence of a new form of employment. There are many features in Go Live. Not this only two. There is Go Massas, Go Clean, Go Automotive, and etc. etc. But I point out these two because this is the most famous and the most problematic one. So Go Massas and Go Clean. So this is the traditional form of employment, and this is now Go Massas and Go Clean relations. If we relations between in traditional employment, relations between independent entrepreneur, the relation is between independent entrepreneur and consumer. In Go Massas and Go Clean, relations is between partner, Go Live, and consumer. And work as independent entrepreneur, and then work as partner, but in reality work as dependent worker under Go Live rules. And then service fee directly from consumer to independent entrepreneur. This is their service fee, 30% for Go Live and 70% for service provider or partner. And then there's definite working hours, target and wage. Working hours, target, bonus, and wage is on demand. So this is how power of Go Live. They have power to set the bonus, daily and weekly bonus, for every service provider that can fulfill particular amount of target. They also have the power to cut the service fee 30%, and rules or policy regarding violation and sanction, including how rating system strongly related to suspension and termination. And these rules again decided unilaterally by Gojek or Go Live. This is the working condition right now. Is it the flexibility and freedom, or an on-demand trap? It's a cheaper service fee. In Yogyakarta itself, in my city itself, it's way cheaper than regular salon, regular parlor one. So it's way more cheaper because it's way more cheaper, and it cut 30%. They will go, they will working all out, and they work without any consideration of working times. So because they have to collecting money as much as they can. They rely on bonus, work more than 8 hours a day, and there is a strict and clear sanction if service provider violates Go Live rules, but there is no protection provided by Go Live if there is any unwanted incident that might harm service provider, considering that service of Go Live is performed in private space. You know, like GoMasas and GoGlive is in consumers' private space, but if there is any accident or incident, any unwanted incident, Go Live, there's no responsibility that Go Live can come. I get hurt, no, but cancellation that without any, without any proof, they cancel like, yeah, it's something like that. Okay, because it is declared as partnership and cannot be defined as employment relation, any labor rights protected by Indonesian labor law cannot be applied. We have, in our Indonesian labor law, we have working hours, minimum wage, overtime wage, social security, health and safety at work, termination of employment. It cannot be applied to this kind of relations because, again, they declare it not as working relation or employment relation, but it's partnership agreement or partnership contract. So this is the possibilities that may come. For example, in Indonesian regulation regarding cleaning service company, it's in the context of GoClean. So after long debate in Indonesia, outsourcing is only, outsourcing in Indonesia only for specific job, like cleaning service, transportation, very specific, and cleaning service is one of them. But there's a regulation that for outsourcing company, outsourcing cleaning service company, it should be in limited liability company. But if a company wants to hire a cleaning service through GoClean, they don't need to fulfill those rules. And it is possible, because GoClean, there's no regulation to that. So there is possibilities that may come. So this is the Go Live's roles, in my personal opinion. They can act as agent or as intermediary when because they connect between independent entrepreneur or between service provider to the consumers, and they take 30% to do that job as agent or intermediary. And they act as, at the same time, they act as employer because they have one requirement to GoMasas, exactly. They have one requirement that, service provider for GoMasas, they need to they need to fulfill the requirements of training, and it conducted by Go Live. It's an obligatory. And they set the bonus, they make rules and policy, extension, and they have unbalanced bargaining positions. And they act as partner when it comes to protection and responsibility. They will go back to partners when it comes to protection and responsibility. So, what about the solution that I can offer? Maybe it's not clear enough. This one is an action, it's a demonstration in Indonesia when driver of conventional taxis want to erase Gojek because it harmed them, because they cannot compete with GoCar. It's called GoCar. They cannot compete with that, and they demand to the government to erase completely Gojek at that time, 2 years ago. So is it in Jakarta and many big cities in Indonesia? So is it the best solution, or we can make the rules or regulation to make it a better situation? So I am interested in what Jeremias Russell ever written about disrupting the disruptors. So if you maybe Mr. You try to to tell us about are we give up yet? For this case in Indonesia, I don't give up yet because we have no option. We have a civil law system, so we need to make a codification to it. We cannot rely on jurisprudence. So that's why I don't give up yet, and I think disrupting the disruptors quite interesting, because Jeremias Presel said that solution for on-demand work or gig economy, it can be the first one, classify them as worker, not independent entrepreneur, identify who is the employer. It stated that how to identify who is the employer. Those responsible for controlling one or more employer functions will have to comply with regulation applicable to their actions. If platform sets its worker pay rates, for example, it must ensure compliance with minimum wage. According to this, GoLive can be identified as employer. Like Faisal said, instead of limit our inquiry to elusive search for the contract employment, asking more intuitive question instead, who's in charge? So that's why it's quite interesting. And a floor of right, classify worker and identify employer is not enough. We need to find a formula of rights to guarantee there will be no precarious work anymore. So maybe that's all from me. A picture of Gojek and GoLive Indonesia, and I hope maybe there are many questions for this. Thank you.
Thank you very much for a very interesting presentation. Przechodzimy teraz do dyskusji. No, mamy niewiele czasu, właściwie kilka minut, ale być może, że jakieś pytania, tak? Są do Pani. Bardzo proszę.
Thank you for that very enlightening presentation. You have made it a truly international conference by taking us to far away Indonesia. Many people didn't know about it. I looked up Wikipedia while you were presenting it. 1 million drivers.
1 million.
Because there are about 200 odd million people in Indonesia. So
Okay.
how can it be 1 billion?
So 1 million. Okay,
Yeah.
my mistake.
Yeah, okay, it's a minor thing, but I just thought that.
Okay. It's still a lot.
But
There's a joke in Indonesia that everyone's going to be the Gojek driver, because like if we go around there, there's a green costume there. Oh, it's Gojek. Green costume there. Oh, it's Gojek. Gojek's everywhere.
Right,
In
right.
Indonesia.
Now my question to you is, since Islam plays such a big role in Indonesia, in Indonesian culture, polity, society, and so on, and Islamic clerics have been very influential, have they weighed into this? Because from what you said, people who are associated with Gojek, particularly the so-called independent contractors, they don't have a great life. And already we are seeing in Indonesia a lot of dissatisfaction about it. Has anyone from an Islamic institution weighed in on this, like the clerics, the mullah, the ulema, anybody, or any social thinker? I just wondered if there is any groundswell of opinion from among the cultural/religious elite in Indonesia. Thank you.
Okay, so unfortunately, the one who think that Gojek have bad manner is only academician. The Gojek driver itself, the Gojek partner itself, they say that it's useful for them. It's much better rather than unemployed. We're ready to work 24 hours a day if it makes money. We don't care if if there's any accident in the road, example. We don't care. That's how maybe Indonesian culture. So Islamic organization or even government, the government say that, oh, it's not my job, it's another ministry. No, it's not my job because it's not employment relations, it's not employment minister. Then go to another ministry, like that. So that's why until now there's no regulation towards Gojek, GoLive, etc. Okay. Okay.
Very much. It's not really a question, more of a comment to your presentation, which links, I think, most of what we've been talking so far. And you said it exactly very well when you said it doesn't matter it's good because it provides work and it provides money. So even if we look at it and we criticize the model is being worked. But I think what is the common ground to all these discussions that we're having is that this new form of employment are actually based on a new form of exploiting work. In some countries, it's developed out of the economic crisis. In some other countries, it's developed out of rates of unemployment which have been intolerable for many years. And this is cheap work which is offered quickly. Unskilled work, not so well paid work, but it's still work. And so the question, obviously, for a government, for the legislator, is not just shall we provide work or shall we have to provide work, but shall we have to provide decent work? Because there is a limit to the amount of work you can give before you actually start thinking, is it decent? And that is a question that every country has to ask itself at some point. So thank you so much.
Czy jeszcze ktoś chciałby zabrać głos w tej naszej dyskusji ciekawej? To może ja jeszcze. Myślę, że zarówno ta sesja plenarna, jak i dzisiejsza tutaj obecna sesja pokazuje nam, jak wiele problemów pojawia się w kontekście zjawiska globalizacji, cyfryzacji, te nowe formy zatrudnienia, które jeszcze kilka lat temu, czy kilkanaście w ogóle były nie do pomyślenia, dzisiaj stanowią pewną rzeczywistość, no, przed którą oczywiście stoi ustawodawca, który ma pewne wyzwanie, tak, do realizacji i myślę, że nie powinien pozostawać tutaj bez jakiejkolwiek odpowiedzi. No tutaj ten przykład Indonezji, ta skala tego zjawiska, taki Uber na globalną skalę, tak, no to już rzeczywiście coś niesamowitego, bym powiedział. Wiadomo, że kultura i uwarunkowania, jakie tam funkcjonują, są zupełnie inne niż w Europie i myślę, że to jest zupełnie inny problem i tam, jak zresztą Pani nie zauważyła, wszyscy właściwie są zadowoleni z tego, prawda, że mają źródło pracy, to jest chyba najważniejsze, tak? Natomiast w Europie jednak bardziej się patrzy na prawa człowieka, na godność, to tutaj Pan podkreślał. Także rzeczywiście jest to kwestia przyszłych wyzwań dla prawa pracy. Wydaje mi się jednak, że ta uberyzacja, ten problem platform, te zależności, o których tutaj Pan mówił, nawet dzisiaj na przykładach tych różnych orzeczeń sądowych, to mimo wszystko jednak jeszcze nie jest stosunek pracy. Takim, nie wiem, ja oczywiście tutaj głównie koncentruję się na tej siatce pojęciowej, którą dysponujemy tutaj u nas w polskim prawie pracy i wydaje mi się, że sam fakt nadzoru, kontroli nad wykonawcą pracy, zależności w takim ujęciu, jakie występuje pomiędzy platformą a wykonawcą usługi, kwestia wydawania pewnych instrukcji, rozmowa kwalifikacyjna, czy nawet w innych kazusach pojawia się ten system płatności godzinowej, który u nas w Polsce w tym momencie właściwie jest realizowany w ramach umów cywilnoprawnych i ustawodawca zalegalizował niejako to, wprowadzając tą minimalną stawkę godzinową właściwie w umowach cywilnoprawnych. Moim zdaniem to jeszcze nie daje podstaw do tego, żeby tych wszystkich wykonawców obejmować stosunkiem pracy i taką ochroną, jaką mają ci klasyczni pracownicy podporządkowani w ramach stosunku pracy. Natomiast oczywiście no po pierwsze wymaga to regulacji prawnej. Nie może być tak, jak mówił Pan w pierwszym panelu, że ktoś jest oceniany, ponosi pewne konsekwencje i nie ma możliwości reagowania, tak, na te oceny, być może przecież niesłuszne, tak, ze strony klientów korzystających z usług. Także tutaj ewidentnie kwestia ochrony praw człowieka, godności tutaj jak najbardziej wymaga zastanowienia, pewnej ochrony socjalnej, no tutaj też możemy się zastanawiać, tak? Nie zajmowalibyśmy się kwalifikacją, to co Pan powiedział, tak? Tych stosunków, gdyby wszyscy ci wykonawcy mieli zagwarantowaną taką minimalną ochronę na określonym poziomie i wtedy myślę, że nikomu by nie zależało nawet na tym, żeby na siłę niejako być wtłoczonym w ten stosunek pracy. Natomiast no, mnie się wydaje, że no, kwestia godności ma swoje oczywiście ochronne gwarancje również w prawie cywilnym, tak? Przecież nasz polski kodeks cywilny reguluje tę problematykę na gruncie prawa pracy polskiego. Pracodawca ma obowiązek poszanowania godności, dóbr osobistych pracownika, ale tak naprawdę jeżeli dochodzi do naruszenia godności, to i tak przechodzimy na grunt prawa cywilnego troszkę, tak? I tam dopiero pojawiają się te konsekwencje. A więc myślę, że ta relacja dotycząca tych platform moim zdaniem powinna być mimo wszystko rozstrzygana na gruncie prawa cywilnego, cywilnoprawnych form zatrudnienia. I tak jak mówiłem w swoim choćby wystąpieniu na sesji plenarnej, no trzeba po prostu się zastanowić, jak daleko w tych cywilnoprawnych formach zatrudnienia, tych właśnie nietypowych, powinniśmy wprowadzać te mechanizmy ochronne, prawda, co do ochrony życia, zdrowia przede wszystkim, no, kwestia czasu pracy, kwestia możliwości korzystania z systemu zabezpieczenia społecznego. To niewątpliwie są problemy, które no, stanowią pewne wyzwanie dla ustawodawcy i myślę, że jutro jeszcze będzie czas na to, żebyśmy wrócili do tych dyskusji. Także dziękuję Państwu za dzisiejszy bardzo interesujący panel i w imieniu organizatorów zapraszam na bankiet, który odbędzie się o godzinie 19 dzisiaj. Także dziękuję bardzo i do zobaczenia jutro.